Well, it's awfully nice to be out here at the Harvard of the West. I must say I'm in awe of lots of things, including your weather. It's a good thing I didn't spend much time here. Before I started my career, I would have started and ended in California and gone nowhere else, I think. I am always amused when I am introduced with one of those clips because I realize it puts me at an enormous disadvantage. You've all been laughing, and you all assume that somehow I'm going to keep you laughing and entertain you the way Mr. Colbert does. Well, I can tell you that he does it very intensively with a very large staff, and he works all day at it. And besides, he's better at it than I am. The first time I went on the show, the staff said to me in the holding room just off behind the curtain, I could hear the roar of the audience. They said, now there's only one piece of advice that's really important. I said, yes. They said, just remember, he's the funny one. So you are stuck with the non-funny one for today at a great conference. I've really been interested in the presentations we've had. Look forward to the others. There are a couple of comments I heard this morning that I want to talk about as I go through my topic because I think there's a lot of good information here. I want you to know that Stanford is not the only educational institution in California which is paying attention to the Colbert Report. After we had done an episode in which, this is, by the way, an actual legal representation of my law firm. I don't charge them or bill by the hour for the time I'm on the show, but we do real legal work for them. And one of them was creating a Delaware corporation as a 501c4, which could then be turned into the Colbert Super PAC committee, which was his C4 that didn't have to disclose its donors, as you've heard about this morning. And after we'd done that whole thing, I was back in Washington, and my phone rang, and it was someone I didn't know who identified herself as a professor of law at Berkeley. And she said, I'm just calling because I really wanted to thank you. That episode you did about the Delaware Shell Corporation, she said, you know, it's a really great episode. I've had a very difficult time explaining to my law students exactly what the role of the incorporator is in corporate law. And now I don't have to. I just show them the Colbert episode. So I'm glad to contribute to new, better ways of learning in higher education. I've been asked to talk a little bit about Citizens United and the developments that we've been hearing about today in the 2012 election, particularly the rise of the super PACs. And I'd like to do that first by starting with Citizens United itself. I will not bore you. I realize it's not a law school class, but I think there's some really interesting things that come out of that decision that influence everything else that's going on now. The first, and I can say this, I think it gets said occasionally, but it still surprises me when I say it, is that with the retirement of Justice Sandra Day O'Connor, the court, for the first time in U.S. history, does not have a single member of the court who has ever held elective office. You started with 3 branches of government, and if you look at the original composition of the court, you look at it over the years, it has primarily been people who had held high elective office, including one former president of the United States, lots of governors, senators, people who had been in the political fray. Justice O'Connor was the last one. She'd been a member of the Arizona legislature, the majority leader, and then had become a judge. The court now is largely people who have come to it from academia or as lower court judges. 2 justices have served at all in government, in the executive branch. But I think Citizens United reflects a real lack of understanding of how politics works, how elections work, how the legislative branch works in terms of dealing with legislative issues before it. And I can't help but think some of that is because Justice O'Connor is not there. She was the swing vote in the McConnell case upholding the McCain-Feingold law, and her departure and the replacement by her of Justice Alito led to the somewhat snappish comment by Justice Stevens in his dissent, talking about how the court was overruling a recent case and overturning about a century of law. And he said, as far as I can see, the only thing that's changed on this court that has required us to do a U-turn on this issue is one justice. And in this case, I thought a really important one. So that was one aspect of Citizens United, is it was decided by a court that I think has lost touch with, has not had touch with how politics actually works, how campaigns actually work. Another aspect of it is that it was decided with really very little record. And the relevance of that is that it came to the court as a challenge to the disclosure requirements of the law. And this group had created an ad, it attacked Hillary Clinton, and they said they shouldn't have to disclose their donors. The Supreme Court turned it into a different question, which essentially looked more like a perhaps con law exam in law school, resolved that corporations have the same First Amendment independent expenditure rights as individuals. Please discuss. And they heard the case. They put it down for re-arguing. They said, this is the issue we want to talk about. So they got a lot of briefs focused on the question of whether corporations should be treated differently or the same as individuals in our political process for purposes of First Amendment speech. They got no briefs on what would happen if they went that way, because that's not the question they had asked, and there was no record in the case of what sort of corruption had created the ban, what would happen if it went away. So the court had a narrow question before it, got a narrow answer, and as I'll explain, I think the problem with that is there are a lot of issues that they didn't think about and are only now becoming aware of. What the court ended up saying in terms of theory is, under our First Amendment jurisprudence, under the Buckley case, independent political speech and expenditures for independent advertising is not corrupting. Go back to Buckley and it says just that. There isn't much of a footnote in Buckley. It doesn't cite studies or facts or anything else. It's a view of the court, sort of reasoning it through, that if you give money to a candidate, they're going to be grateful. If the same person makes an independent political expenditure, totally separate from the candidate, totally independent of the candidate or a party, which is the language in Buckley, then it might be a good or a bad expenditure. The candidate won't be particularly grateful. It might even backfire. But since there's no coordination with the candidate, there's no opportunity for the sort of gratitude that might yield corruption concerns in a contribution setting. So that's the court's big theory here, untested until now in real life. They say, okay, we know that independent expenditures are not corrupting as a matter of law. Individuals have been able to make them since the court's Buckley decision in '76. We don't see why corporations shouldn't be able to make them too. We can't see any reason for the government to treat corporations in their political speech differently than it has treated individuals for the last 30-some years. As a result, we hold that corporations can make the same independent expenditures that individuals can. The two other aspects of this decision I think are important and often get overlooked when people are using that catch label. The court said that corporations are people, which is not exactly what they said. But the other two pieces of the decision are, first, that Justice Kennedy went out of his way to narrow the definition of corruption, which is important because since the Buckley case, the court has said the government cannot regulate political speech for the purpose of, let's say, making sure that all speakers are equal or that all voices are heard to the same degree or any of those things that get characterized as leveling the playing field. Instead, the court has said The only reason you can regulate political speech is to prevent corruption. That's a legitimate government purpose. Otherwise, there isn't one. And so really for maybe 20 years, the court has been arguing back and forth over, well, what is corruption? If you can regulate it because it's corrupt or has the potential to corrupt, which was another phrase out of Buckley, then what constitutes corruption and therefore justifies the regulation? And in the court's 5-4 decision in McConnell, it took a pretty broad view. McConnell was a case which had, very unusually in this area, been argued with a huge record, thousands of pages of expert testimony, of polling data, of depositions of key witnesses on both sides, all before a 3-court district court panel. So the court had a lot in that record to describe how campaign finance actually worked. And in the majority opinion, they cited what were then the sort of garden variety practices of the political parties, like selling access. You get an invitation and it says for $100,000 you get a private meeting with so-and-so, for $50,000 you get a meeting with a group of people, and it went down the list because that's how parties were raising soft money in the more egregious ways. And the court was clearly offended by that in the McConnell case and said that's exactly the sort of thing that can support government regulation. We shouldn't be selling access. Justice Kennedy, in the Citizens United case, narrows this considerably and says corruption is quid pro quo. It's basically bribery. It's, you give me money, I give you my vote on an issue. And that is all, he says, the government can regulate, which affects obviously not only corporate speech, but all the areas of campaign finance and what individuals can do. The other area of Citizens United is disclosure. And the irony here is that, as I noted, the case came to the court as a disclosure case. The court ruled 8-1, so all the dissenters joined 4 of the 5 in the majority, that the government had a legitimate interest in requiring disclosure of the sources of money in campaigns. And they broadened that. There had been a debate over whether you could only require disclosure of what's called express advocacy, which is vote for or against a candidate. And the court said, no, you can require disclosure of election speech, a much broader category that would include talking about candidates in an election period. So that was the gist of Citizens United. There was one other piece in that, which was, I think Justice Kennedy may be putting the gumdrops on top of the frosting on top of the cake, which is, having gone through the theory that I just described, he ended up saying, in very broad language, the government has no business at all choosing between political speakers. That's not the government's business. As citizens, we get to hear anyone who wants to talk to us, and the government can't decide which speakers to allow us to hear and which not, which, as I say, was another justification for saying corporations can speak without limit, but as I will explain in a moment, it had other potential meanings. So that's Citizens United. The next piece, which is sort of the caboose on this train, but a very important one, came about 6 weeks later. It's a decision in the D.C. Circuit called Speech Now. This was a challenge that had already been there when Citizens United was decided, to the limit on what individuals can give to political committees. Political committees are groups of people who get together to spend money in federal elections. They file with the FEC, and up until 2010, there was a limit of $5,000 that an individual could give to a political committee. This group of people said that limit shouldn't apply to us because we are a group of people, we want to spend money in federal elections, but we're going to spend it on independent expenditures. We're not going to give it to candidates. And therefore, since independent expenditures, the Supreme Court has said, aren't corrupting, you shouldn't be able to limit how much we can give to a committee that only does independent expenditures. And the D.C. Circuit in Speech Now says, this case is decided by Citizens United. The Supreme Court has said there is no corruption with independent speech, therefore there's no governmental interest in limiting independent speech, therefore there's no governmental interest in limiting contributions to groups that only make independent speech. That was the birth of the super PAC, because the FEC took that decision and said, well, if we can't limit it, then we're going to create something called a non-connected political independent expenditure only committee, which was too long a phrase for the press, and so they called it a super PAC. But it's a federal committee that can accept unlimited individual contributions because of Speech Now, unlimited corporate contributions because of Citizens United, or unlimited labor contributions, and it can aggregate all that money, and it could spend it in unlimited amounts in federal elections. So that was the package that came out of Citizens United. Now, a couple thoughts on this. One, I was really interested in Bruce Owen's presentation this morning, and his point that I think people are beginning to focus on, which is this whole issue of what's corrupt and what's not, and therefore what can the government regulate in terms of campaign finance. Because Bruce says, you know, members of Congress are not crooks. This isn't as if they're taking the money and putting it in their own pocket and absconding with it. They are receiving this money, soliciting this money for political purposes. I might quibble a little because he says it's not really personal, and I've always thought that, you know, someone's career is pretty personal. Their ability to succeed in public life and rise up the greasy pole is in some senses the most important thing to many people. But nonetheless, he's right. I mean, this isn't venal. They're not crooks. The problem we have is that the court appears to have said in Citizens United, unless they loosen up here, that you can only regulate people when they're being crooks. And so if they're not crooks, if they're instead doing what Professor Lessig calls his type 2 corruption, I keep thinking of, you know, diabetes or something, but this notion that there's another form of corruption which is really systemic and doesn't require people to be sinners, but does require us to acknowledge that the system has problems in it. It appears that Citizens United has said the government has no business trying to stop that type of corruption. And that is going to be a real problem going forward if we end up concluding, as I think a rational person would, that we have corruption in the system, whether or not we have crooks in the system. So that's one issue. The other is the whole issue of corporate decision-making. I, as you might guess, am not a great fan of Citizens United. The Campaign Legal Center, which I had filed a brief urging the Supreme Court not to do this. And my concern had been focused on just exactly what a corporate actor is and isn't in politics. And the argument that I have been trying to make is that corporations are, in fact, different than people. As Colbert said in one of his shows, gee, I haven't seen one walking down the street recently. It's not good or bad that they're different than people. It's just that a corporation is a collection of individuals, but with a very specific purpose. All of us in our lives are multidimensional people. We are, we hope, moral actors. So we make decisions based on what's good for us economically, what's good for our families, what's good for our grandchildren, whether we're for or against war is a religious matter. We have a complex, sometimes conflicted decision-making mode. That should not apply to corporations. They are supposed to be one-dimensional under the law. Their job is to make money for their shareholders. You know, that's what they're supposed to be doing. If it means moving overseas, people may criticize them for political reasons, but that's a good economic judgment. So my problem is when you have corporations that are only supposed to be figuring out how to make the best economic outcome for their shareholders, making political decisions. Because as we heard in the discussions this morning, those political decisions involve how do I get the best deal out of the government? How do I screw my competitor and make sure that they don't get as good a deal? If I'm covered by that law, can I get them covered? There are these very clear economic outcomes that corporations seek. So I thought Adams's presentation was really interesting because when you look at his slides and he says, well, you see, corporations are really much more diverse than people think, and they're much more liberal than people think, look at how their boards of directors are giving, look at who their officers are supporting, it's true. But I would go back and say that actually, I think, proves my point. The people in them are multidimensional. But the people who are going to make the decisions about how to spend corporate money in elections are, if they're doing their job for the corporation, going to put a lot of that aside and focus on what is the best economic outcome here for the corporation, not the country, not all those other interests, which is, I think, one of the dangers of having purely corporate money out of corporate treasuries in elections, rather than those individuals who are more diverse and making their decisions on a broader basis. And if you look at how it works in fact, what happens is the shareholders don't make those decisions. The board of directors usually don't make those decisions. The CEO does, or the vice president of government affairs does, based on the advice from the Washington lobbyist who says, this is our bill and here's how we move it. So the whole decision-making process narrows and funnels it until it points to the desired economic outcome. The other thing that happened in Citizens United is that Justice Kennedy, and I'm actually usually a fan of Justice Kennedy, so I should say I think he was misled here, and he was ill-served by there being no record. But Justice Kennedy made a mistake. He said, today, for the first time, corporations are going to be allowed to spend corporate treasury money in elections, and it will be fully disclosed. And shareholders will know how the corporation is spending its money, their money, and can act accordingly, and voters will know who is paying for all of these ads. That is not how it has worked out. First of all, and many of you know much more about corporate governance than I do, that's not how corporations work. Shareholders don't, they may in a theoretical sense own the corporation, but they don't govern it. We don't have town hall meeting democracies for corporations. Board of directors do. They defer to the board under corporate law. The business judgment rule says the board gets to decide how to do these things. Secondly, corporations in many cases don't disclose to shareholders how they spend their money. So shareholders can't even object noisily. Then, in terms of outside of the corporate context, voters understanding who's funding these ads, as Sheila and others have explained, that may or may not be true. We don't have the system that Justice Kennedy thought we had, where the law required full disclosure by these political actors. Political committees, super PACs, have to disclose their donors, which works fine unless their donors happen to be shell corporations created by somebody to make the $1 million contribution and then close down as soon as the contribution is made. And if you think I'm just being a scaremonger, that's exactly what happened to at least some donations this year, where the press looked at a corporation they'd never heard of and said, who is it? And did a little research and discovered it had been newly created. The only thing it had done was make a contribution, and then it had disappeared. So PACs more or less disclosed, but the other big spender is the nonprofits. C4s, which are social interest groups that individuals can give to, C6s, which are business trade associations, like the Chamber of Commerce. They are never required to disclose their donors to the public. As Sheila noted, they don't even have to disclose the fact that they have donors until the year after the election, because they're set up under the tax laws as nonprofits, not as a political committee. There was not thought to be any importance to timely disclosure. So we don't have the disclosure that Justice Kennedy thought we had. Then, finally, in terms of, I think, the problems with Citizens United, the court operated on this assumption that these were going to be independent expenditures. Now, there are two things here. First, they'd never heard of a super PAC. Remember, it came in the decision afterwards. So they're in a world where the only independent expenditures they have seen are about, I'm not even sure I need all my fingers to count them. In the 30 years since Buckley, there have been a handful of cases where wealthy individuals took out advertising to attack a federal candidate, and they put their name at the bottom because that's what the law required. So that's what the court was thinking, that if there were corporate expenditures, it would say paid for by GE. So instead you have super PACs, everyone can aggregate their money, and you have these C4s, so that you don't actually, doesn't say paid for by Trevor Potter, it says paid for by Americans for a Better Tomorrow tomorrow. And nobody knows what that is. And they all sound alike. So that's one problem, is the court hadn't anticipated this would all be done through somewhat anonymous political groups. The second problem is the court thought it would be, said it would be, totally independent of candidates and parties. Because that's what they said. They didn't know anything about how it worked, but they looked back at Buckley and said, well, if it's independent, that's what it means. Well, as anyone who is awake in this room knows, that is not what has happened this year. We've had this bizarre entity called a candidate super PAC, which means an independent committee coordinating closely with a candidate, except when they're not allowed to coordinate. And the only thing they're not allowed to coordinate on is where to run the advertising and what it says. So that you have all these situations where these super PACs are created by close supporters, donors, and advisors to candidates. You can imagine what happened in the closed room when someone said, gosh, we need a super PAC. And you look at who's running, and it's the people who used to work for the candidate. In some cases, until yesterday, used to work for the candidate. The fundraising is done by the people who are raising money for the candidate. They can hire the same pollsters and the same advertising people if they want, if there's a division of labor inside the firms. And most importantly, to making this whole structure work, and I think to making it, giving it the potential for corruption, is the candidate can endorse the super PAC and can raise money for the super PAC, can go to meetings with the donors of the super PAC. Now, you can argue about whether this is a good idea or not, but it surely is not totally independent of the candidate. So the court just has never dealt with this. That we're in a different world than they were. And where that goes going forward, I think it raises some interesting legal questions. So what happens from here? First of all, roles of super PACs and C4s. They've clearly been really important in the presidential primaries. They've kept the Republican one open much longer because the only funding for Gingrich and eventually Santorum was their super PACs with a handful of donors. In the Lugar primary, very large expenditures by super PACs against him. So they have been playing an important role in the primaries. If you just look at the dimensions of this, I think we're maybe a little inured to how extraordinary it is. Sheldon Adelson. I don't know Mr. Adelson. I have nothing against Mr. Adelson. But if you had told me 2 years ago that a single person and his family would be able legally to spend $25 million to elect someone president while meeting with them in private meetings and saying that his goal in doing so was to elect someone who had specific foreign policy goals that the candidate shared, I would have said that isn't how the system works. I had a call the other day from a mainstream German reporter, so I don't think he was pulling my leg, and he was trying to understand this whole system so he could explain it to his readers. And he said, I need to ask you a question about the role in America of the oligarchs. Now, it's sometimes interesting to hear a different view of it, but you start looking at people spending $25 million to elect this candidate and someone else spending $6 million to elect that one. It's a very small world. Sheila would have better numbers than I, but just to the publicly disclosed super PACs, the number of people who have given 90% of the money is tiny. So it's a small group. Then, as I've said, we've got these C4s and C6s. They will be active. We won't know who their donors are. We don't know what they're raising or spending unless they actually take out TV advertising time, because that's a public fact. You'll know from the stations that they bought it, and they'll file a report with the FEC that says they are opposing and supporting candidates under some circumstances. But there's going to be a lot of money, even that's spent on advertising, that doesn't fit within what's required to be disclosed. And then they're going to spend money on things that they don't have to file reports on. George Soros just announced he's giving $2 million to the Democratic super PAC to do on get out the vote and so-called ground activity. He chose to announce it publicly, so we know it. He didn't need to, and the group never would have told us. If he gave to the C4, it never would have been public. And the fact they spent it wouldn't be public because they don't disclose that. So don't underestimate. I think there's a problem for political scientists, which is if you can't see it, it's hard to estimate, so we stop talking about it. Remember that there's a fair amount of spending in the C4s and the C6s that we're not going to see. So I've received the hook, so I'm going to leave some time for questions. I will just tease you with the following thoughts if you want to follow up on questions. One, there's a case called Montana in the Supreme Court now where the state of Montana is essentially challenging Citizens United. And it's interesting because 2 justices have said this is an opportunity for the court to reconsider its holding in Citizens United that independent spending cannot corrupt. There are challenges, actions, complaints before the IRS, petitions before the SEC to require more disclosure of spending to shareholders. There are arguments in books and before Congress on public funding or constitutional amendments. So what I foresee going forward is a very fertile, fluid area of campaign finance discussion over the next while. Thanks.